Fine. Then I think now we move on to the discussion panel. The first will be Mariella Bottiglieri, which we thank that she made it all the way from China to be with us today here. She's Managing Director of Giuseppe Bottiglieri Navigazione. Please, Mrs. Bottiglieri.
Thank you, Chairman, and thanks to the organizer for such an interesting speech. I enjoyed the three of them, but I would like to focus especially on the piracy presentation by the Hill Dickinson legal firm. As a director of the UK Defence Club in London, I'm very proud to say that the Saldanha case that you mentioned was one of our cases that we decided to support since the very beginning. And we were, of course, very happy when the final decision arrived by Mr. Justice Gross in June 2010. So I would like to say that on one side we have very good news on piracy matters. On the other side, unfortunately, a few days ago, the Italian Navy was obliged to release 7 pirates because, of course, there is a very big lack of rules and regulation. What are the means that you could suggest we could use in order to try to face piracy under a legal point of view? Thanks.
The answer is not shooting them in the head, I suppose.
Bruce has turned the microphone to me, which is very kind of him. I suppose I asked for it by talking about piracy. I think when you approach piracy, you have, first of all, the distinction between what we might loosely call public international law and the private or the contractual position. And I think it's very difficult for a practicing lawyer to address the public international law question, which will only be changed, I think, by conventions, by activity with NATO, the United Nations, by reviewing the rules on armed engagement with the pirates. So from where and frankly, from a practicing lawyer's point of view, we don't really deal with those aspects so much. The deterrent question was at the heart of the Maysfield case. And it's very difficult to think of a way of getting around a situation because you talk, I can see it's very unattractive to have to release pirates. But the only way you can deal with it as a live issue, I think, as an operator, is by following the best management practice and what is recommended to you, and probably ultimately, when there's a seizure, by paying the ransom. So from a contractor, a jobbing lawyer's perspective, I don't think there is much you can do. You just have, as a ship-owning community, to lobby hard, to explore whether the European naval force is sufficient. And of course, there's another jurisdictional question. Wherever those pirates were released, you have to take it up in that jurisdiction which has considered whatever they have done to be such that you can release them. It's not criminal activity. They might be able to return. I'm not aware of the facts of your case, but that's probably the third dimension. You've got to look at it at on a state-by-state basis.
Then Carlo Cameli, General Manager of Fratelli d'Amico Armatori, please.
Good evening, Mr. Chairman, and speakers and panelists and delegates. I'd like to focus just a second with Mr. McInnes about the vetting issues. First of all, an observation. There is no doubt that in recent times, oil companies have tightened even more their requirements and their minimum criteria for accepting ships for their trades. The result is that in a moment in which the market is not at all helping, the tanker market is not at all helping, we have to spend more money instead of saving money, which we should be doing. But we have to be competitive, and to be competitive, we have to spend more money. There is a lot of good tonnage around, an ample choice by the charters, no commercial pressure. So either we are top quality or we don't get the business. Having said that, we also have to defend ourselves with in charter party clauses. We do have to guarantee that we are approved by majors, as you clearly stated. It is okay to say that we will keep the ship approved. Which is different is, especially on spot charters, that we are guaranteed that the ship is approved at the time of fixing by certain companies. So, in fact, we are saying something false, as you said, because the ship is not approved. There's no blank approval. The ship, maybe even if the ship has been inspected, and even if it's possibly inspected, we do get a letter in which it says that she's not approved, but will be screened each time. So what defense have we got? We have to accept, it's a case of the dog that beats its tail. We have to accept the clause, otherwise we don't fix. But on the other side, in the moment we accept the clause, we know already we're in breach. Thank you.
Thank you for that question. I mean, I think it's a fair comment that as an owner, you're in a very difficult position. And the only thing you can do is negotiate and put in the best wording you can, rather than warranting that it is approved and you identify exactly the problem. The oil majors just don't give you a certificate saying this ship is approved for 12 months. Each cargo, they make a fresh decision. And incidentally, they may change their criteria without telling anyone. So you just don't know where you stand as an owner. But you just need to be smart and do the best you can in the circumstances. So instead of warranting that, you have to say the same vessel for 3 years. But that's what they agreed, and that's what they were stuck with, the same as the case I mentioned, where the owners didn't amend Clause 43 and they paid the price for that. I just wanted to come back on the piracy case, which, coming from Ince & Co., who represented the successful owners, I'm also very proud of. But Mariella Bottiglieri's question on what can be done, I mean, it's right that there are private contractual questions, but piracy is illegal under public international law. And any state can arrest pirates and try them and put them in prison in the same way as any other breach. It's akin to a crime against humanity. So I don't think it is a problem under international law to deal with pirates. What it is a political problem that no states want to actually arrest the pirates and put them in prison and keep them there. But they could do it under international law, they just don't want to do it.
I think Mr. Clive Hassan want to add something. Just a second.
It's really just a small point to add about oil majors' approval, but to put it in the dry cargo perspective, that reference was made briefly to rightship. And of course, for dry bulk operators, there are problems with rightship approval, where obviously if there is a requirement of rightship approval, the position is clear. But very often there's no requirement of rightship approval, but the charterers will ask for a rightship inspector to go on board, or they may ask for certain information to be provided to rightship in order that they can trade the vessel down the line with rightship approval. This is also an uncharted area. The case that went through the court last year said that even where there's no clause requiring rightship approval, the owner is still obliged to permit the rightship inspectors on board to do an audit. But it isn't purely a question of inspection, it's often a question as well of providing documents. I was involved in a case recently where a vessel had a grounding, and rightship wanted to ask very intrusive questions about the grounding. The owner didn't want to provide that information because he was involved in a safe port dispute with the charterer. So there are just as many of these rather difficult questions arising on the dry side. It's by no means limited to tanker tonnage.
Thank you. And now we have Giuseppe D'Amato, Chairman of the Perseveranza SPA, please.
Chiedo scusa se parlo in italiano. Oltre ad essere sempre più stringenti, i requisiti richiesti variano da oil major a oil major. È possibile ipotizzare che in un prossimo futuro le oil major si accordino per definire gli stessi standard di ispezione, di modo che con una sola visita si ottenga un'approvazione valida per tutte le majors? Questa è la mia domanda, però con il permesso del mio Presidente Di Francesco vorrei parlarvi di un argomento che non è in programma, ma che è di estremo interesse e riguarda un po' tutti quanti. Voglio parlarvi della demolizione delle vecchie navi. Sapete che negli anni scorsi, un po' per la facilitazione datasi dalle banche, un po' per l'esplosione del mercato, si sono ordinate migliaia di navi che stanno venendo in mercato ancora oggi, ma la cosa peggiore è che questa follia si continua. Ancora adesso si ordinano migliaia di navi, per cui prima o poi il mercato si saturirà. Cosa succederà? Io ricordo all'inizio degli anni '80 noi prendemmo una nave, una Panamax, che venne consegnata in Brasile. Ebbene, rimase 3 mesi senza impiego. Ma non è che c'era un nolo scadente che non valeva la pena, non c'era proprio niente nel modo più assoluto. Qualche noleggiatore diceva: vuoi fare il viaggio, al massimo ti pago il bunker, che allora costava pochissimo. Allora si sono demolite navi di 8-9 anni. Ora, cosa succederà se contemporaneamente all'immissione di tante nuove navi ci sarà anche una riduzione dell'espansione della Cina? Immaginate, negli anni '80 non c'erano tante navi in arrivo, non c'era la Cina. Oggi invece è possibile la riduzione dell'espansione della Cina e con l'arrivo di tante migliaia di navi ancora, la crisi sarà ancora peggio e durerà ancora di più. Ora, secondo me, c'è la possibilità di evitarla. Da un sondaggio fatto nel luglio scorso risulta che le navi vecchie, superiori a 25 anni, rappresentano il 50% circa delle navi in ordine fino al 2013. E le navi superiori a 20 anni, che quindi col passare del tempo saranno anche superiori ai 20 anni, arrivano addirittura al 70%. Quindi con la demolizione di queste navi sicuramente potremmo avere un equilibrio fra domanda ed offerta. Questo discorso io l'ho già fatto al mio Presidente e guardate, questa conferenza è un arricchimento per noi tutti, però purtroppo stasera andando via finisce tutto. Io vorrei proporre di creare un gruppo di lavoro che segua questo problema, che ripeto è gravissimo, con i governi, con l'Unione Europea, con tutti gli enti internazionali riguardanti lo shipping, con le compagnie di assicurazione, con il P&I, con gli istituti di classificazione e soprattutto con gli armatori, perché in effetti come si risolvono le crisi? Perché poi le crisi si risolvono. In effetti, questo lo dico per le banche, non temete perché prima o poi la crisi si risolve in ogni caso, ma perché arriva al punto di mettere in condizioni tante aziende di entrare in difficoltà? Perché poi in effetti il risultato sarà sempre quello. Per risolvere la crisi normalmente si demoliscono le navi. Allora pensiamoci prima di creare problemi per tutti quanti. Perciò se è possibile, Presidente, creare questo gruppo di lavoro che intervenga su questi enti in modo da sensibilizzare un po' tutti quanti perché questo si verifica. Grazie, Presidente.
Grazie a te, Peppino.